Welcome, dear students, to the next lecture of Land Laws, Unit 2. Today, we are going to deal with the scope and application of the Land Acquisition Act 2013. And we are also going to discuss about the important definitions of the Act so that we have a good understanding of the various terms which are used in the Act, and we can understand the uh, understand the various provisions of Land Acquisition Act. I'm going to share the PPT with you. So this is your second unit that deals with the urban development and regulations. And the topic for today's lecture is the scope and application of LAR Act 2013 and the important definitions under the same act. The suggested reading, students, you can refer the textbooks, Taxman's Guide to New Land Acquisition Law, Taxman's publication. You can also refer Kamal V.P. Singh's Land Laws. And for further readings, you can refer N.K. Acharya's Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act, and the BEAR Act as well. The relevance of today's topic of discussion is mainly to focus upon the scope and application of the Act of 2013. And also to understand various important definitions for the purpose of critically analyzing the provisions of the LAR Act. Considering the outcome of this topic, you will be able to understand the concept of law of land acquisition by understanding important definitions of the Act. And you will also be able to critically compare and classify the various provisions of Land Acquisition Act, the old and the new one. Students, we had a brief introduction of scope and application of this Act in our previous lecture. Now we will discuss it in detail, that what is the scope and in what conditions the Act is applicable. As you all know that this Act, Land Acquisition Act, Rehabilitation and Resettlement Act of 2013, this Act has been enacted under concurrent list. That means, and it has enacted by central government, and it includes all types of land acquisitions, whether the land is acquired by the central government or the state government. That is why the words in place of government, the words used are appropriate government. So here, appropriate government is the government, whichever is applicable, as the case may be. In case of if central government is acquiring land, then central government, and in case the state government is going to acquire the land, then the appropriate government will be state government. So first of all, it includes the scope in the scope of Act of 2013. All land acquisitions, whether done by state government or the central government, are included within the scope of the Act. So Section 2 provides for the application of the Act, and it provides various provisions to various types of land acquisition. And for this purpose, it classifies the acquisition of land into three categories. So there are three categories of land acquisition, and further, there are provisions of acquisition which are further divided into four categories. So first of all, the three categories which deals with the acquisition of land, and then the further under these three categories, there are provisions dealing with these three categories, which are further divided into four categories. Let us concentrate on firstly on the three types of land acquisition. So under section 2, clause 1 provides for the appropriate government where it that is appropriate government means the central government or the state government, as the case may be, where the appropriate government acquires land for its own use, hold, and control, including land for public sector undertakings for public purposes. The ultimate purpose of acquiring the land here is the public purpose. We will be discussing public purpose in detail in the upcoming slides. For understanding this clause 1, that here the appropriate government is acquiring land for its own use, hold, and control. That means here the transfer of private property is going to be shifted. The ownership, sorry, ownership of the property is going to be transferred to the government, because the ultimate use and the possession and control of the land now will be taken care by the appropriate government. So in this case, the ownership is going to be transferred to the appropriate government, where and also where this is going to be transferred to public sector undertakings. Clause 2 provides that appropriate government, when acquires land with ultimate purpose to transfer it for the use of private companies for stated public purposes. So this part includes the public-private partnership. The 3 Ps stands for public-private partnership. So here, the again, appropriate government is going to acquire the land, and its ultimate object of acquiring this land is the public purpose. But here, the one more purpose, that this is being done in a partnership with some private company, like this is why it is called public private partnership. Maybe sometimes like Reliance, it is coming up with some project of for the public purpose, and it joins hand with the government, and they may need land. In such cases, the ownership of the land which is going to be acquired remains with the government. It shifts from the owner of the land to the government, but here the use of the land will be done by the private companies. So यहाँ पे use private company करेगी, but the ownership will remain with the government. Now, coming towards the clause 3, that appropriate government acquires land for immediate and declared use by the private companies for public purpose. In all the 3 categories, one common thing is the public purpose, that the land is being acquired for a public purpose. In first category, the government, the ownership is transferring to government, and government is going to use, hold, and control of the land. Then in second category, the ownership will remain with the government, and the use and possession of the property will be held by private companies. And then in third category, appropriate acquires land for immediate and declared use by the private companies for public purpose. In such cases, private entities sometimes they go and directly negotiate with the owners of the land for coming up with some project, but they can request, in such cases they can request the government to acquire the land on their behalf, and in such cases the ownership of the land will be transferred to the private company, that is the private entity. So now, coming towards the main provisions of the Act. So we have classified firstly, Act is classifying the land acquisition in 3 categories. Now, on these three categories, what are the provisions which are the main provisions of land acquisitions are provided under the provisions of the Act? So main provisions are classified as by section 2 in 4 categories. So what are the provisions which are going to be applicable on various types of land acquisition? Acquisition by government for its own use. Secondly, acquisition by the government for in public-private partnership. And thirdly, where private entity is going to be the owner of the land and it can request it can request the government to acquire on their behalf. And now the provisions are further divided into 4 categories. The provisions relating to land acquisition, which are given provided under section, you can see 4 to 9. Then these provisions, these particular sections are the sections which are applicable to the provisions of land acquisition. You can say the procedure must be followed, which has been given provided under these sections 11 to 25, 38, 40, 91, and so on. Then provisions relating to consent. So this is provided under section 2 clause 2, first proviso. That is where the public private clause 2 subclause 2 provides for the public private partnership land acquisition. So where the private company is joining hands with the government. So in first proviso, it requires consent of the affected family. We are going to discuss it about in the upcoming lectures. And then thirdly, the provisions relating to compensation, which are provided how to calculate the compensation, how to determine the amount of compensation, how in the manner in which it is to be given, and what are the additional amount which can be given as solatium. So this is provided under section 26 to 30, 39, and 96. And the lastly, provisions related to rehabilitation and resettlement. So these are the provisions when the affected persons who are whose land has been acquired now must be rehabilitated. So it was the provisions of rehabilitation and resettlement have been given under section 30, 32, 41, 42, 46, 47, 96, and second schedule of this act and the third schedule of this act. So now students, we will discuss that in what category, what type of land acquisition, what are the provisions which are applicable. So this is the applications. To try to understand the application of the act, that we discussed that section 2 subclause 1 provides where appropriate government acquires land for its own use, hold and control, including land for public sector undertakings for public purpose. So in such category, the very first category of land acquisition, the provisions of land acquisition, compensation, and rehabilitation and resettlement shall apply. So where the appropriate government is going to acquire the land for its own use or for public sector undertakings for public purpose, then where the ownership is going to be transferred to the state. In such cases, the provisions relating to land acquisition, you can see the provisions from section 9, 4 to 9, 11 to 25, 38, 40, 91, 92, 95, and 199. Then compensation provision, 26, 30, 39, 96, then rehabilitation and resettlement provision, which are provided under sections 30, 32, 41, 42, 46, 47, and 96. So these are the provisions. You can see which provision is missing here. The provision, there are only 3 provisions given here. That means here the second provision is missing, that is provisions relating to consent. So now understand this, that where under section 2 clause 1, when appropriate government acquires land, it only need to follow the requirements given under the provisions of which are dealing with land acquisition, and it provides for compensation and rehabilitation and resettlement. It is not, the government is not required to get the consent clause here. So the consent clause is not applicable in the land acquisition which has been provided under clause 2, subclause 1. So now subclause 2, let's see. Subclause 2 provides for two type of land acquisition further, and that is provided under clause subclause A and subclause B. So this provides for clause 2, subclause 2 provides for when appropriate government acquires land for public-private partnership projects. So PPP. So three P's: public-private partnership projects for public purpose, and where the ownership of the land continues to vest with the government, then the private then the provisions of the act which are applicable in such kind of a land acquisition are land acquisition, provisions of land acquisition, provisions of consent, provisions of compensation, provisions of rehabilitation and resettlement shall apply. And in case of this type of which is provided under clause A, that is the public-private projects, the prior consent of at least 70% of affected families shall be obtained. And the consent process shall also be carried out along with social impact assessment study. So both social impact assessment study as well as the consent proceedings will be carried out similarly and at the same time. So this under public-private partnership, the consent of at least 70% of affected families is required. If 70% of affected families are giving consent to such acquisition of land, then only state government or central government, as the case may be, can go further to acquire the land. Now, part B of the same section that provides that when appropriate government acquires the land for private entities for public purpose. In clause A, it is mentioned that public-private partnership. So now here, the government is acquiring land for private entities for public purpose. Then the provisions of provisions of the act which are relating to land acquisition, consent, compensation, and rehabilitation and resettlement shall apply. All the four categories shall apply in both the cases A and B, but the difference is that here, in case of public-private partnerships, the consent of at least 70% was required, but in this case, which is covered under subclause B, the consent of at least 80% of affected families shall be obtained before going for the acquisition of private properties of the private persons. Then and same, the consent process shall be carried out along with the social impact assessment study. So now we'll go towards section 2, subclause 3. It is again further divided into two parts. Part A, where a private entity purchases land, and purchase is through private negotiations. So directly here, the non-interference of the state. Here, private entity, it is purchasing the land, directly contacting the farmers through private negotiations with the owners of the land, and purchase is in accordance with the provisions of section 46, and land purchase is equal to or more than such limits in rural areas or urban areas as may be prescribed by the appropriate government. So now in this case, the provisions of the act relating to rehabilitation and resettlement shall apply. So because this under this clause, private entities are directly contacting the landowners. But again, this is being done for public purpose. So in such cases, they are contacting the private persons, and they are directly in touch with them. They are privately negotiating with them about the compensation and all. So they will be, whatever they have discussed, they have settled that what kind of compensation, maybe in kind, maybe in cash, maybe in shares in their company. whatever they have negotiated with the owners, so that is settled. So they should they are not required to follow the provisions of land acquisition, consent, and compensation, right? So in such case, only they are required to follow the provisions which are provided under rehabilitation and resettlement. Now, considering the clause B of subclause 3 of section 2, where private entity requests the appropriate government for acquisition of a part of an area so prescribed for a public purpose. So here, the provisions again of the Act which are relating to rehabilitation and resettlement shall apply. In other words, the provisions relating to land acquisition, consent, and compensation will not apply. And again, in such cases where private entity is requesting the appropriate government that for acquisition of a part of an area so prescribed should be acquired for, again, for public purpose. Now, I hope you are clear with the concept, with the scope and application of the um, Act, and what are the conditions, what are the categories of land acquisition, and what are the provisions in which case these provisions are applicable. So now coming towards the important definitions of the Act. So very first important definition is public purpose. So public purpose, the definition of public purpose is given under section 3 ZA, and which provides for that it is only stating that all the activities which are specified under subsection 1 of section 2, and that is the application where again the application 2 section 2 subsection 1 provides where the state government, or you can say the appropriate government, is acquiring the land for its own use, hold, and control along with the public sector undertakings for public purpose. And what is this public purpose is explained under that subhead. So section 3ZA only provides that all the activities which are specified under subsection 1 of section 2. And what is now section 2 subsection 1 is providing for all the activities which are for strategic purposes relating to naval forces, military forces, air force, armed forces of the Union, including central paramilitary forces, or any work vital to national security or defense of India or state policy, safety of the people of India. So this will be covered under the strategical purposes. So for strategic purpose which are relating to the defense, naval, military, air force, all the armed forces of Union, including central paramilitary forces, or any work vital to national security or defense. Now, for infrastructural projects, which includes the following, namely, after strategical projects, here comes the infrastructural projects. So all the activities or items which are listed in the notification of Government of India in the Department of Economic Affairs, that is infrastructure section, and by dated 27 March, and all the private hospitals, private educational institutions, and private hotels. So this definition provides for the infrastructure projects, but in the new in the initially when the act has been enacted, they have excluded private hospitals, private educational institutions also. But in the new definition, after in the ordinance of 2014, it has included private hospitals, private educational institutions as well, excluding only private hotels. So now, for the purpose of infrastructure project, private hospitals, private educational institutions have been also included. Then projects involving agro-processing, supply of inputs to agriculture, warehousing, cold storage facilities, all are covered under the infrastructure projects. Marketing infrastructure for agriculture, allied activities, and what are the ancillary and allied activities to agriculture? Dairy, fisheries, meat processing, set up owned by appropriate government or by farmers cooperative or by an institution which is set up under the statute. Then again under infrastructure projects for industrial corridors or mining activities, national investment, manufacturing zones as designed in national manufacturing policies, then projects for water harvesting, water conservation, structures, sanitation, then again projects for government administered, government aided educational and research schemes or institutions. Then any infrastructure facility as may be notified in this regard by central government and after tabling of such notification in the parliament. Coming to the next project, this has complete the infrastructure projects. Then projects for project affected families. So under this, there must be some projects for the purpose of affected families, for the purpose of rehabilitating them, and resettlement of the affected families. All are covered under such projects. Then project for housing for such income groups as may be specified from time to time by the appropriate government. So to provide with the such income groups with housing scheme is also covered under the public purpose. So it is very exhaustive definition, you see. Then projects for planned development and improvement or improvement of any site in urban area or provision of land for residential purposes for the weaker sections in rural or urban areas. Then project for residential purposes to the poor or landless or person residing in areas which are affected by reason of the implementation of any scheme and any law made by the government, any local authority or a corporation owned and controlled by the state. So the definition of public purpose in section 3ZA, read with section 2(1) of the Act is very, very exhaustive. In the old Act, it was very wide definition. So it was very difficult to interpret what is termed as public purpose. So now they have provided for a very exhaustive definition, and now we can exactly interpret what is the public purpose. And this is clear from the use of words means in section 3ZA, from the use of the words shall include in section 2A. So this, the interpretation, interpretative words mean and shall include. This public purpose means and it also shall include. This is exhaustive definition and from the context of the Act made clear in the statement of objects and reasons as well. What is public purpose? And otherwise, if we look at the Black's Law Dictionary to find out the meaning of public purpose, it denotes the objects for which taxes may be levied. All the objects on which taxes may be levied, and it has no relevance to the urgency of public need or the extent of public benefit, the essential requisite being that a public service or use shall affect the inhabitants as a community and not merely as individuals. So the general welfare of the general public at large is going to be benefited by this project. So this would be public purpose, where the public at large is going to be benefited. Then a public purpose has for its objective the promotion of public health, safety, moral, general welfare, security, prosperity, and contentment of all the inhabitants or the residents within a given political division. that is the state, political division, country at large. So this, we are not focusing on a private person or set of persons, public at large, general public. So that would be the public purpose. The next definition is the affected family, which has been given under section C. Who is the affected family? So it gives an inclusive definition of affected family, again, which includes affected family, which includes a family whose land or other immovable property has been acquired, and a family which does not own any land, but a member or members of such family may be agricultural laborers, tenants, including any form of tenancy or holding of usufruct right, croppers, artisans, or who may be working in the affected area for 3 years prior to the acquisition of land, and whose primary source of livelihood stands affected by this acquisition of land. So this would be also covered under the definition of affected families. So who are working as tenants, artisans, laborers on that land which is going to be acquired 3 years prior to such acquisition, and they were dependent on such land for earning their livelihood. Thirdly, affected family covers the scheduled tribes and other traditional forest dwellers who have lost any of their forest rights recognized under Scheduled Tribes and Other Traditional Forest Dwellers Act 2006 due to acquisition of land. So any person from scheduled tribes or any other forest dwellers who's enjoying some kind of forest rights which were recognized in the 2006 Act, and they will be also considered as affected family. Then family whose primary source of livelihood for 3 years prior to acquisition of land is dependent on forests or water bodies and includes gatherers of forest produce, any hunters, fishers, boatmen, and such livelihood is affected due to acquisition of land. This would be affected family. So now coming towards next definition, which is agricultural land, section 3D. Land used for purposes of agriculture or horticulture. It will be agricultural land, land used for dairy farming, poultry. These are the ancillary to agriculture. Dairy farming, poultry farming, pisciculture, sericulture, seed farming, breeding of livestock, or nursery growing medicinal herbs. All this will be ancillary to the agriculture, agriculture or horticulture. Raising of crops, trees, grass, or garden produce, and land used for grazing the cattle will also be categorized or is covered under the definition of agricultural land. Then, what is the cost of acquisition, which is provided under section 3, subclause I? Cost of acquisition includes the amount of compensation, which includes salatium, any enhanced compensation ordered by the Land Acquisition, Rehabilitation and Resettlement Authority or the court, and interest payable on thereon. First, the amount of compensation, including salatium amount ordered by the court or authority, and interest payable thereon, and any other amount determined as payable to the affected family by such authority of the court. This will be the cost of acquisition. Then demurrage to be paid for damages due to caused due to the land standing crops in process of acquisition. Again, those damages will be paid. Then cost of acquisition of land and building for settlement of displaced or adversely affected families will also be considered as the cost of acquisition. Cost of development of infrastructure, amenities at the resettlement area. Now, where the government is going to resettle or rehabilitate the people, all the costs which is going to be incurred upon that resettlement area will also be included in the cost of acquisition. Then cost of rehabilitation and resettlement as determined in accordance with the provisions of this act. Then administrative costs for acquisition of land, including both in project sites, out of project area lands, not exceeding such percentage of cost of compensation as may be specified by appropriate government. And in case of rehabilitation resettlement of owners of the land and other affected families whose land has been acquired or proposed to be acquired, or other families affected by such acquisition, will be considered as administrative cost. Which is further and covered under the definition of cost of acquisition. Then cost of undertaking social impact assessment is also covered under the cost of acquisition. Next definition is entitled to act, section 3L. This is the person who is entitled to act on behalf of some other person. In relation to a person shall be deemed to include the following persons: any trustee for other persons beneficially interested with reference to such case, and that to the extent as the person beneficially interested could have acted if free from disability. So firstly, trustees. Secondly, the guardians of minors and the committees or managers of lunatics to some extent, as the minors, lunatics, or other persons of unsound mind themselves, if free from disabilities, could have acted, they will act in the same way. So trustees, number one. Secondly, the guardians will be the persons entitled to act in place of the persons. Next is land, section provided under section 3P. Land includes the benefits to arise out of land, and the things attached to earth and permanently fastened to anything attached to earth will be considered as land. Maybe some building is there on the land, a well has been constructed on the land. So anything which is attached to the earth or permanently fastened to the earth will also be considered as land. Next is landowner, provided under section 3R. Landowner includes a person whose name is recorded as owner of the land or building or part thereof in the revenue officer's concerned authority, then who is granted forest rights under STs and Scheduled Tribes and other Traditional Forest Dwellers Act 2006, or under any other law for the time being in force, he would be landowner. Then who is entitled to be granted patta rights on the land under any law of the state, including assigned lands, he will also be considered as landowners. It is also inclusive definition, landowner who has been declared as such by an order of the court or authority as landowner, he will be a landowner. Then the person interested under section 3X provides the person interested means, firstly, all person claiming an interest in compensation to be made on account of acquisition of land under this act. Any person who is saying that I claim the compensation because I am going to be affected, my livelihood is going to be affected, I was a laborer on that land. So any person who is claiming an interest in the compensation will be interested person. Secondly, the Scheduled Tribes and other traditional forest dwellers who have lost any forest rights recognized under the Act of 2006, he will be interested person. A person interested in an easement affecting the land will be interested person. Persons having tenancy rights under relevant state laws, including sharecroppers, by whatever name they are, may be called. Any person whose primary source of livelihood is likely to be adversely affected will be person interested. So these persons interested will get the compensation. Next is requiring body, section 3, ZB. This is means requiring body means a company, a body, corporate, an institution, or any other organization for whom land is going to be acquired by appropriate government. So under application, we have discussed clause 2, subclause 3, where private entity requests the government to acquire the land for prescribed part of prescribed area, and now that means this company is a requiring body, and the requiring body, it only needs to follow the provisions of rehabilitation and resettlement. The term includes the appropriate government if the acquisition of land is for such government either for its own use or for subsequent transfer of such land in public interest to the company. body corporate, an institution, or any other organization, as the case may be, under lease, license, or through any other mode of transfer of land. Small farmer, marginal farmers, provided under Section 3, ZE and ZE. Small farmer means a cultivator and of an unirrigated land holding up to 2 hectares, or with an irrigated land holding which is up to 1 hectare, but not more than holding of marginal farmers. Marginal farmers, an unirrigated land holding up to 1 hectare and 1/2 hectare. Affected area means such area as may be notified the appropriate to be the area for the purpose of acquisition. Resettlement area means an area where the affected families who have been displaced as a result of land acquisition are resettled by the appropriate government. Lastly, displaced family, Section 3K, means any family who on account of acquisition of the land has to be relocated and resettled from the affected area to resettlement area. So this is the end of slideshow. Now I hope you are clear with the scope and application of the Act, as well as the important definition, which is very necessary to understand in detail the further provisions of the Act. So see you in the next lecture. Thank you so much.